News in South Carolina tonight, the murder convictions tossed against Alex Murdaugh. He still remains in prison on financial crime convictions, won't be getting out anytime soon, and we have viewer reaction.
We do. We also want to make sure that you know you can text the number that we're going to be sharing throughout our newscast today. That way you can share your questions, your concerns, your thoughts, really whatever you want to say about this. Here's that number. Take a look right here. It is 803-776-9508. That way the experts can then share their reaction to whatever questions you're asking.
Criminal defense attorneys Luke and Brian Shealy with us now. And one viewer says that Alex deserves a new trial, and while his ego prevents him, he should take a deal that works along the same time frame of his federal sentence. Could there be a deal here? I mean, to avoid another lengthy, costly trial?
There could be if the state offered one. I don't think they have any interest in offering one, but murder carries 30 to life. So it's day for day sentence, unlike some of the other sentences he's serving, they're not day for day. So the state would really have to see some kind of struggle with their evidence or some other concern, which we didn't really see much from in the Attorney General's briefing. That happens a lot on retrials, but this one is just so high publicity and means so much to so many people that I doubt they'd be offering anything other than you can plead straight up to murder if you would like. And everything from the first trial seemed to indicate that he was very principled about the fact that he didn't kill his family.
I'm curious, as we wait for more viewer questions to come in, you all shared the news conference and you shared your reaction to that. But for folks who are just now joining us, was there anything that the state attorney general said at the podium that surprised you? And I understand it was very long, but is there anything in particular that you honed in on?
I felt that they were acknowledging out the gate kind of the rules that they have to play by at the trial level, the next trial. And that is certainly referencing the Supreme Court's opinion on the financial crime allegations. And the Supreme Court said, basically, guys, give it a rest. You can't get 6 weeks of, financial crimes. You can't have all these witnesses. You really need to tone it down. And so I was a little bit surprised that Alan Wilson made reference to that he was going to, they would look at that. I kind of assumed it would be more just the energy to prosecute again. And they did speak to that and doing it efficiently, but they did reference kind of the guidelines that they'd have to be subject to based on that opinion. And that caught my attention.
Yeah, a little bit. The Supreme Court didn't decide the case based on that, but they gave guidance, which is helpful, and everybody can read the room. And they're basically saying, look, we're not saying you can't do it if the trial judge lets you, but if you do try to do it short and quick, because they pretty much said that what they did the last trial did cause unfair prejudice to Alex Murdaugh. And that wasn't what they based their opinion on, but they're just saying. So whatever gets presented, the state isn't going to want to abandon that because it's so tempting to say, he's a bad guy, look at all the bad things he did, therefore he killed his family, which is the exact opposite reason why you really should be doing that. You should be saying, let's decide this case on the facts and the law, so the defense attorneys will be citing to this ruling and saying, hey, the Supreme Court says, yeah, maybe you can do it in some circumstances, but it's really not a good idea. Look where we are now. We're having to do this thing all over again. So you're going to have a big battle. I don't think the state abandons it entirely, but they will try to maybe tone it down.
Did I hear? Oh, go ahead.
Go ahead.
Did I hear the state attorney general correct when he said they have 90 days to appeal the ruling?
Yeah, procedurally, they've got time to ask for a petition for rehearing. If that gets denied, they can go to the U.S. Supreme Court. They're not going to do that, I don't think. It was a unanimous decision. You have to basically, when you ask the court to reverse itself, you have to kind of show them something new that they haven't really considered. This is baked in. All justices agreed. And I think they're not going to just waste everybody's time. I think they're probably not going to do that. They're just going to plow down and say, all right, let's pick a new date. Let's pick a new date. But he wasn't trying to pigeonhole himself on camera live today. It just happened. He's going to talk to the appellate division of the Attorney General's office, say, hey, do we have anything? What do you guys think? But I think it's not going to happen.
This remains a high-profile case. It got a lot of publicity when the trial happened. A lot of people were watching daily as the trial unfolded. Is there a chance this go around that the defense can say, we don't want cameras in the courtroom? And if so, what's the basis for something like that?
I think, you got to balance, and that's ultimately up to the court. And in my experience, cameras, if media wants to be present, they're going to get in. They're going to get in. I think the more important thing to the integrity of the trial itself is going to be selecting the jurors to make sure that they're fair and impartial. I think the cameras are certainly going to come in. There's a lot of rights to that, access to the court and a public courtroom. I don't think there's nothing that's going to be more prejudicial than what's already occurred with the Becky Hill stuff, and that is not because there are cameras in the courtroom. I think the biggest thing is going to be picking a proper venue, like where is this thing going to get tried? That'll be a huge decision for a future court to determine. There'll probably be a lot of legal wrangling about that because the Attorney General has an interest in trying it back in Colleton County. I guarantee you defense counsel will have a different thought on that, and there'll be some argument on that. And then I think free access to the court will occur, but I do think this case, given the not just national but international attention to it, you're kind of in a spot where if you find a potential juror that doesn't know about this case, then it's like, well, are they even qualified to serve because they got some other stuff going on? I think it's just going to be really appropriate to do enhanced jury selection. They call it voir dire, attorney-conducted voir dire, which in South Carolina, criminal defense lawyers don't normally get to ask these advanced, extensive questioning unless it's a death penalty case, and then we get to do it. I think this retrial will demand that kind of vetting of potential jurors to make sure they're fit, make sure they can be fair and impartial given the international spotlight on this.
We have a viewer response, I believe, with a question.
Yes, so one response and reaction really that we're getting from you all is that this person wrote, I believe Alex Murdaugh is guilty. He deserves a new trial based on the clerk, Becky Hill's actions. I hope he is held or she is held financially responsible for the retrial cost.
That's not happening, right?
Nope.
No.
The taxpayers of the state of South Carolina are going to be held responsible for the retrial cost because the Attorney General also basically said we're an office seeking justice. Cost is not a factor, but they get their funding through the state. So every SLED agent, every expert, all of this because of Becky Hill is going to cost the taxpayer dollars more. Now, Mr. Murdaugh, he's going to have to pay for this on his own dime on his side of things, employing his attorneys, trying to retain experts that he thinks will do the job for him this time. But it is a shame. It's a waste of resources for sure. There's a lot of people looking for their day in court, and now this will take up a substantial amount of time, and they'll have to take a back seat. But there will be a substantial cost to it.
Brian, I know the defense was hammering home the point that no DNA evidence was found on any of Murdaugh's clothing. They never found the actual murder weapon. There was no DNA evidence connecting Murdaugh to the murders. Is that something they might retool here and hammer home even more?
Absolutely, and everything is wide open again, JR. And this was a circumstantial case, purely a circumstantial case. And some would argue they got the conviction because of dragging Alex Murdaugh through his own lies on the other matters, getting him to admit that he was a liar and a thief on these and the financial issues, and then kind of bringing it home to help bolster the circumstantial evidence. But yeah, everything's wide open again. I think the defense will retool, look at those issues. I mean, they may employ different experts. They may want, a new strategy, new avenues that they could have attacked better, maybe they think. So I think, yeah, it's still a circumstantial case up until the point that new evidence comes out. From the state perspective, I don't think anything new is going to happen because their main goal will be to just get this to a jury as quickly as we can. And then I think for a defense perspective, they're going to say, well, whoa, let's not rush everything. Let's look at this. Let's pick and choose the right moment. Let's get the venue figured out. Let's get the jury voir dire figured out. Let's get a proper jury, proper venue, and whatever else they've been thinking about for years now that no one knows.
Well, you just said, let's get it to a jury as quickly as possible. I know a lot of folks who are watching are asking about a possible timeline for the next steps. I mean, what is your prediction?
I think once our Supremes let the public digest this opinion, the next thing they will do is appoint a circuit court judge to hear it. In the past, you've seen how they've done that, right? They selected former Chief Justice Gene Toll. So they'll appoint, just like they did with Cliff Newman, they'll appoint a judge to handle this matter exclusively. That judge will then get the parties together to try to come up with a scheduling order based on where we are with the evidence, where we are with other outside matters, what venue are we going to select. We're going to have probably motions and arguments on those issues as well, which will take time. So we got to find a judge, and then I think everything after that will be scheduled in a timely way. But again, there are certain things that you can't rush on a case like this, because here's the thing: no one wants to do this the third time. We've all seen, a roadmap to how this was improperly done, mostly with Becky Hill. The court's given us some guidance on what the state probably should have avoided. So everyone has a vested interest in a retrial. Both sides have a vested interest. Let's get it done right, get it done properly. And that typically in a court of law on a criminal matter is not a fast thing. It normally means, the cautious thing, the prudent thing is to take it with, where time's not such a consideration. You just get it done the right way.
Slow down.
Fascinating input
right.
from our criminal defense lawyers. Thank you so very much. They're with us throughout the evening. We're going to take a quick break.